Do you know who's sitting behind you? You've got families from across the nation whose children are either severely harmed or gone.
With the courtrooms closed, every American abused by all the companies in front of me.
I think the time for all of this immunity is done.
Section 230 gives big tech companies nearly unlimited immunity from legal consequences.
Congress must act because big tech will not police itself.
Time is up for big tech.
The parents of this country are demanding it.
It is now time to repeal Section 230.
I'm here because there's a law right now, a federal law, that protects big tech and not our children.
Removing Section 230 immunity, it doesn't mean that the First Amendment doesn't apply to those platforms and they suddenly have to remove all the content. There still would have to be somebody who's injured.
Questions carrying. What the hell were you thinking? I understand get resources.
Yes or no? It's got to end. There are no more excuses.
Wow, that was powerful. Good morning, good afternoon, and good evening to our friends from across the globe. And welcome to the National Center on Sexual Exploitation's 2025 Dirty Dozen List Reveal. My name is Marcel van der Watt, and I'm the president here at the National Center on Sexual Exploitation. Our mission here at the National Center on Sexual Exploitation is the mass-scale prevention of sexual exploitation and abuse. For over 60 years, we've led this fight, tackling issues like child sexual abuse, sex trafficking, pornography, and image-based abuse. For several years already, the Dirty Dozen List campaign, and through the work that we do here at the center, we have seen remarkable victories with companies such as Google, Netflix, TikTok, Walmart, Verizon, and even the United States Department of Defense. But today we are facing one of the most significant challenges yet, and that is CDA 230. And as you've seen, CDA 230 is literally occupying every place on this year's Dirty Dozen list. And today we'll hear how all of these issues are being unpacked, and knowing also that victory is close, and repealing Section 230 is no longer a question of if, but when. So without further ado, I'm going to invite my amazing colleagues, Haley McNamara, Senior Vice President of Strategic Initiatives, and Dr. Eleanor Gaitan, VP of Public Policy. Thank you.
Today's briefing should be powerful. We're going to start by hearing from a mother whose family was turned upside down because of online criminality. Jane Doe will lead us off in a recorded video, and then two panels. The law panel will talk about this law past and future, and the impact panel will talk about the negative consequences of a Section 230 internet.
So make sure to leave your comments and ask questions in the chat or wherever you are watching this. Time permitting, we will try to answer some of those questions during our panels.
Marcel mentioned already the unique fact about this year's Dirty Dozen list is that instead of 12 companies, we are featuring 12 survivor stories, people who were shut out of courtrooms as a result of Section 230.
So please go to dirtydozenlist.com where you can read about their cases in full. Today we are hearing from Jane Doe, a mother whose son was tragically exploited online. She has been anonymized in order to protect her child's privacy in their ongoing legal case. Please play the interview.
Jane Doe, we are so grateful for you joining us today to share how Section 230 has directly had an impact on your family in the wake of, unfortunately, an already traumatizing series of events. For those who aren't familiar with your case, could you share about what your family has experienced?
Yes, thank you, Haley, for having me today. One night, I was told that my 13-year-old was suicidal. This was devastating for us. I rushed into his room to find out that he had been threatened and coerced into creating pornographic images with another friend. The boys were threatened that if they didn't continue to keep producing the images, that they would be released online into his community, which they were. My son hasn't been the same since that day. The worst nightmare came true. A compilation of videos were placed online and they were released on Twitter. The company is now called X. When I realized this, we immediately reached out to Twitter. We went through their platform and asked them to remove these videos, and then on multiple occasions, we filled out multiple forms. Twitter did not remove the videos, but instead they left them up after they looked into it. Twitter asked for my son's ID, and then they verified his Florida ID and knew that he was underage. Twitter then emailed us back and said that they had reviewed the illegal videos, but they knew his age, and they still refused to remove the video. It was left up for 9 days. Every single day was just more traumatizing, us trying to figure out how we were going to get these down. Every single time that the video was shared and viewed was just an additional re-victimization for my son and us. We reached out for help. It was only through the grace of God that I was able to find a federal agent who was able to then force Twitter to take down the illegal images. We filed a lawsuit against Twitter for benefiting from sex trafficking and knowingly possessing child pornography. They didn't take it down, so they knew about it. Our case was dismissed because of Section 230.
So obviously, before this case, you probably had never even heard of Section 230 of the Communications Decency Act. How do you feel now about that law and how it's impacted your family?
So we had never heard of it. I didn't know anything about this. So the everyday parent, just, working and being in your family life are not familiar with all of these things. So yes, now I'm familiar with it, but to become aware that there's such an act that has created a space online where big tech companies are not made by law, really, or to have to take down images of child abuse material, pornography, child pornography videos or images is. I think most families don't even realize that this stuff is happening, and that I think is when I do explain, not telling our story, but trying to advocate for trafficking people, it's people are blown away that this is even allowed and that it's happening. I mean, it's mind blowing that this protection is there. And I don't think it was ever intended to. I don't think that act was placed there with this intention, of course, but this has been the result of it. And a lot of families are hurting, have been hurt, are affected by this, and that we can't seek any type of justice due to it.
What message would you like to send to lawmakers?
I would just like to ask that they come alongside us, that they come alongside communities, and that I'm sure that each and many of them have children and grandchildren, and that this could happen to their children. I'd like for them to take into consideration to help us the way to fight for us the way that they would fight for their own children and grandchildren, that this can happen to any family.
This can happen to any family. That's Jane Doe's message. How did we get here? How is it possible that child pornography, which is a severe federal crime, is rampant on the internet, and it's very hard to get it down once it's up there, and it's very hard to hold these platforms liable? We got to go to lawyers. So we're going to start with our first panel. Professor Mary Graw-Leary is professor of law at Catholic University of America. Laura Marquez Garrett is senior attorney at the Social Media Victims Law Center based in Washington State. Lisa Haba is a partner at the Haba Law Firm in Florida, and Kristen Price is senior legal counsel at the National Center on Sexual Exploitation, my colleague. Let's start with you, Mary. Is Section 230 of the Communications Decency Act still serving its original purpose, and how has it been misinterpreted by courts?
Hold one small technical difficulty. One moment, Mary. We're going to restart your answer to make sure that we can all hear you. As with any live production, there's always something that happens.
Yeah.
Yep.
Let's move instead to Lisa. Lisa Haba, some people argue that we need Section 230 to prevent frivolous lawsuits. Do you think that's a valid concern? I don't think we can hear Lisa either.
Is that better?
Perfect. Lisa, thank
Okay,
you so
great.
much for answering that question.
So I do not think that's a valid concern. I actually think conflating Section 230 and frivolous lawsuits is a bit of a red herring. And when you compare the two, really, I think the point that you have to look at is what is the intent behind each law? There's a rule in the federal civil procedure called Rule 11. Most lawyers are pretty familiar with it, that allows for sanctions to be imposed against anybody who has filed a frivolous lawsuit or has filed a frivolous motion or put something before the court that lacks merit. There is a mechanism built into law for every single case that goes before a federal court to make sure that those matters are not frivolous. Completely separate apart from that, we have the matter of CDA 230. And the intent behind CDA 230 was that we wanted to have a free and open internet. When it was codified back in the 90s, the whole point was to allow a very coming up business. The internet was not what it is today. It's not the Goliath that it is today. At the time, it was just beginning. And at that time, they wanted to make sure the internet was allowed to let speech flourish, allow commerce to flourish. And as a result, they wanted to make sure that platforms weren't going to be held accountable for what third parties might do on their platforms without their knowledge.
Yes.
Granted, this was before social media existed. But CDA 230, the point is to make sure that a platform is not being held accountable for third parties' conduct. What that has turned into, though, through over 20 years of case law interpretation, and as we've gone down almost a rabbit hole of interpretations to where we find ourselves now, platforms are blatantly engaging in criminal conduct, and they're being given a pass for it. And so if we were to move forward in this day and age, we need to live in the modern world where our laws have caught up with the modern day society and the internet.
Thank you so much, Lisa. Let's go back to Mary. Mary, what I asked was whether or not Section 230 is still serving its original purpose and how it's been misinterpreted by the courts.
Sure. And my able colleague talked about if it's still serving its original purpose, which it isn't. And she highlighted one purpose that is mentioned when this act was written in 1986, but that's really a minor purpose. When we look at what was happening in 1996, excuse me, Congress was about to look at the Telecommunications Act. They had this new modern thing coming down the pike called the internet, and they realized they needed to update the laws because under the old system, broadcast television, telephones, there were rules in place that protected children from abuse, exploitation, and limited their access to disturbing content. And Congress, in its wisdom, said with this new thing, cable television being among the things they considered new, they said, gosh, this could be really bad for children. So they wrote the Communications Decency Act. And we often refer to Section 230 just as Section 230. I think we should all get used to saying the whole sentence because that reminds us what Congress wanted to do. It's Section 230 of the Communications Decency Act. And if you look at the text of that act, it is very clear what its main purpose is. This emerged out of a landscape of trying to protect children. Congress saw the threat and took actions in order to protect children. And this particular provision is the title of Section 230 of the Communications Decency Act is the blocking and screening of offensive material. It was designed to promote limited protection for Good Samaritan platforms. So to my colleague, Ms. Haba's point, a platform should have the protection from civil liability to remove things from its platform. That's what it sought. And the text of the statute is quite clear. Congress explicitly says it wants to enforce criminal prosecution and it wants to enforce a vigorous protection of children. That was the purpose. And the way we got here, as Ms. Haba laid out for us, is both inside courtrooms and outside courtrooms, an intentional campaign from the tech industry to distort that statute into a broad immunity.
And Laura, I would love to hear from you this legal landscape that has been laid out for us. How does this impact the incentives of online platforms today?
Sure. So, excuse me. So Social Media Victims Law Center, we filed our first lawsuit in January of 2022. We identified dozens of dangerous and defective product features and essentially begged big tech to make their products safer, specific changes they could make quickly, and they still haven't. In fact, in October 2023, a federal court asked these companies what duty do they have to adolescents using their platforms to design those platforms in a safe way. Their answer was, and I quote, that duty does not exist under the law, right? So that's how these companies are still using Section 230. So here we are, more than 3 years later, the most dangerous product features are still in play and children are still dying. In fact, we are a 6-attorney firm out of Seattle, Washington. More recently, we've been retained on behalf of 94 children ages 10 to 21 who died in 2023, 2024, and even 2025 alone. So yes, we have more pieces of the puzzle than when litigation started, but that should be viewed in light of the fact that we are fighting with every odd stacked against us, right? Every legal issue takes months to navigate, and we have maybe one attorney and one expert for every couple dozen on their side. Now, fortunately, we have something they don't, which is a reason to never give up, no matter how long it takes. But even with all of that, we might be able to get to trial before the end of 2026. Meanwhile, every month these companies delay, they're making millions. Every year, billions and thousands of more American kids are harmed. More government and consumer speech is censored, and these companies keep telling courts there's nothing anyone can do to stop them. These companies are ignoring the stuff that we raised the red flags about 3 years ago because safer products mean less money. And I'd like to give an example. Imagine an automotive industry with no safety standards and no testing requirements. And each time a car explodes, the deceased consumer's family not only has to prove the precise part was defective, but also disprove every other possible theory the car company can dream up to blame someone else. We would have manufacturers cutting corners, no safety testing, no safety features, and they'd be making a lot more money, right? Because that's how it works. So essentially, these companies, this is what they've done with 230, except their products didn't exist when 230 was enacted. They got in through the back door by just telling us not what they weren't doing, like not telling us what they were doing. So the last point I'd make is we are making progress in litigation, but it shouldn't be this hard. Until Congress and the courts fix what's broken, we are going to be constantly struggling just to scrape the surface of what these companies are doing to kids and what they could be doing to make their products safer by design.
What about, I offer this maybe first to Kristen Price, but then to all of you. In 2018, there was an amendment to Communications Decency Act, Section 230 FOSTA, SESTA, and it seemingly had the mission of clarifying that this broad immunity should not be given to websites that are knowingly facilitating sex trafficking and prostitution. Did that fix the issue enough, or why does more needs to be done?
No,
Kristen, we can start with you, but then open it up to others as well.
No, the short answer is that it didn't fix things. FOSTA did clarify that Section 230 immunity doesn't extend to websites that are sued for sex trafficking. And just on background, the federal sex trafficking statute covers both direct perpetrator liability and what's called beneficiary liability. So for civil lawsuits, this means a company can be liable if they knowingly benefit from what they ought to know is sex trafficking. But judges, unfortunately, have consistently interpreted the language in FOSTA to require even more than that from plaintiffs, to show specifically that the website's conduct meets a heightened criminal standard. And we have seen judges consistently in the different cases go out of their way to interpret Section 230 as broadly as possible, and then FOSTA as narrowly as possible. We even have rulings essentially saying that a website has to knowingly, overtly participate in the sex trafficking to be liable for benefiting from it, which completely defeats the point of having beneficiary liability at all. The whole idea behind it is to be able to stop the enablers and the profiteers in this, who aren't directly transporting or recruiting victims, but who are certainly getting their cut.
So well stated, as always, Kristen. Do you have any of the lawyers inspired questions of each other?
If I could just jump on to what Ms. Price said, I think that the Sesta Fossa example indicates why we need a full-fledged revamping of Section 230 and repealing it as opposed to piecemeal approaches. Two reasons. One is the piecemeal approaches don't really work. Sesta Fossa is a good piece of legislation, actually, and it should be used more. But to Ms. Price's point, this demonstrates what tech does, what all of my colleagues have said on this panel. They know why the language is how it is in Sesta Fossa, and that language was narrowed to respond to some of their arguments. But what do they do before the ink is dry on the carve out? They go in a court and say it says something else that they know was not the legislative intent. And that's why carve outs for Section 230, this idea that we can tweak it a little bit, is simply not going to work and doesn't stand up to reality. The only thing that needs to stay with Section 230 is the Good Samaritan immunity, which incentivizes platforms to clean up their content, as opposed to how they have perverted this other language, which says that they don't have to do anything with regard to third-party content.
So if I could just jump in here as well.
Please.
I think it would be instructive to understand exactly what happened with FOSTA, just to give you a real-life example of what we're describing here. So with FOSTA, this great carve-out came out, and it was supposed to be something that would make such a difference and allow for cases just like Jane Doe's case against Twitter to go forward and to have an opportunity to have an open court and to have an opportunity to prove their case. But just like in Jane Doe's case and many others, there was a case called Reddit. Reddit was out of California in the Ninth Circuit, and Reddit was really going to be the fundamental case that has interpreted in many jurisdictions, has been the foremost case that has interpreted the FOSTA exception. And what it looked at was the language of the FOSTA exception. And the textual language reads, any civil claim brought under Section 1595, which is the Trafficking Victim Protection Act, if the conduct underlying the claim constitutes a violation of Section 1591 of that title. So to give that context, if a civil claim is brought under the civil provision of the Trafficking Victim Protection Act, the conduct underlying the claim must constitute a violation of the criminal aspect of that. 1591 is the criminal portion of the Trafficking Victim Protection Act. So what did the court interpret? They interpreted that to meet the civil standard, the website's conduct itself, the website itself has to be engaged at a criminal level of criminality. So now if the website is not themselves acting at a level where they could literally be prosecuted under 1591, the courthouse doors are closed and nobody can bring a case. How can a civil plaintiff who has been sex trafficked through a website, the website has benefited from it, all of the standards that are required by 1595, the civil cause of action, have been met, but because they can't prove that the website acted criminally in a criminal context, their courthouse doors are closed. What that effectively does is it collapses the statute for 1595. It takes what was beneficiary liability and direct liability, collapses them into one, and requires a civil plaintiff who should be able to plead their case under either theory to only be able to pursue a direct trafficker theory against a website because of the way that this has been interpreted. And this is exactly to Professor Leary's point, what tech has done. They have walked into the courtroom, they've said one thing to Congress, they walk into court, and they say something else. They talk about the intent of Congress, they talk about what the court should look at this, the textual interpretation, and time again, they have been persuasive in taking Congress's language, twisting it into something that was not intended, and we end up with a mess like we have now. I support exactly what Professor Leary is saying, that we need to get rid of Section 230. I will say that one thing I would believe that would support some of the arguments I've heard against this. I've heard there's been a lot of discussion about we need to maintain free speech and things of that nature. I would propose that limiting Section 230, in addition to what Professor Leary has said, limiting Section 230 to still offer protections against defamation would make sense, but there should be no protections for criminality. Websites should not be benefiting and profiting from people selling drugs online, people selling pornography or child pornography online, people doing criminal conduct and using a website in plain sight to do it with the website's knowledge. Obviously, there's a difference between having defamation online where a website is not aware of it and having direct criminal conduct occur. When we're at a stage where child pornography is being knowingly possessed by a platform, openly distributed, and money is changing hands left and right, and there's nothing that a court can do about it, we're at a point where something has to change.
If I could just piggyback on what Lisa said about the criminal conduct, just to underscore that a little bit. A lot of these platforms, they will create thumbnails of CCM as like a preview of the content that is on there. And so they're creating their own unique CCM. And the courts are saying that even that blatant criminal conduct isn't sufficient to overcome Section 230 immunity.
Wow, thank you so much. And I did have time to get a quick question in from our audience. I hope this is open to any of you to answer, and then we'll go on to our final question. Someone wrote in and asked, how would my experience online be impacted if Section 230 disappears? Would this impact my free speech?
If I can comment on the free speech aspect as the resident law professor. Free speech is often used in this debate by tech as a sword. The First Amendment, first of all, limits the government, not a private company. Secondly, the First Amendment is designed to help guide us through some sticky questions, right? When people's rights come up against each other. It is not meant to say we can't legislate at all. And when the tech companies say things like, this implicates speech, you can't regulate me at all, that is the equivalent of the following example. It is illegal to commit robbery. It's illegal to pull a gun on someone and say, I want your wallet. The tech company's argument would be saying, well, the criminal said, I want your wallet. We have a free speech right to say that. Okay? We don't do that. It is still illegal in America today to commit robbery. And there is no speech defense for that because it's an act. And what these companies are doing is engaged in actions, not engaged in speech, and it will not affect anyone's free speech rights participating in the internet. Section 230 has almost nothing to do with the First Amendment, and when it does implicate speech in some ways, on a case-specific basis, the courts will navigate that with the case law around the First Amendment, not with Section 230.
Thank you so much, Mary. I hear the free speech argument on Capitol Hill all the time, so I'm going to re-listen to what you've just said and memorize it. Thanks a lot.
And for our final question, well, actually, Laura, would you have any additional thoughts on that, on the user's experience or free speech?
Yeah, I actually just unmuted because I know the two big arguments I think I hear most often are, one, couldn't this hurt small companies who could get sued? And two is the free speech. And I actually think I can respond to those sort of together. First, I would actually say not fixing things with 230 is harming small companies. From the ethical designers and engineers I've spoken with, they can't compete in this market. And it sort of boils down to something as simple as, you're not going to get many takers for sparkling water when these companies have turned consumers into alcoholic and they're giving away alcohol for free, right? So as these companies are creating harmful dependencies, it is very difficult for ethical companies, small companies, to compete. And it would be really beneficial to our economy to open up the playing field in that regard. Second, we're talking about real harms to real kids. We're talking about dependencies that are so severe that kids will die by suicide when they can't keep using. We're talking about companies like Meta knowing if they just slowed the speed of their algorithm a little bit at night, kids and other consumers could make the choice to look away, could go to sleep instead of suffering from sleep deprivation and related harms. I want to give a more recent example because it's so on point here. In April 2021, Snapchat executives met with a group of grieving parents and said, sorry, your children have died. You can't sue us because of Section 230, right? These are fentanyl poisoning cases. And so they begged Snap to simply warn children, to warn parents about counterfeit pills being pushed on the platform, to take down dealer accounts when Snapchat knew that this was happening, and to cooperate with police. Now, I recently started working with a father whose 16-year-old son died in December of 2024. This dad agreed to allow Snapchat a few months prior after he checked the Apple App Store rating, after he checked Snap's materials, and there were no warnings, right? In fact, it said this is safe for kids as young as 12 years old. His son was 15, almost 16. So he said, fine, you can use Snapchat. He didn't know that drugs were a thing on Snapchat, and his kid didn't know that counterfeit drugs were killing children on Snapchat. I want to add it turns out, we find out after, that Snapchat had been subpoenaed by law enforcement 60 days prior to when this boy died, 4 months ago. It didn't respond at first, and then it didn't provide instructions. So now you've got a 30, 45 delay for law enforcement. But even after Snap provided police with the evidence of drug dealing through this same account, it didn't close the account, right? So this is one example of thousands. It has nothing to do with free speech. And I guess at the end of the day, when it comes to the small companies, the last point I'd make is, if a small or mid-sized car company was out there selling cars with exploding parts, would the size of the company matter, right? You don't get to sell cars that explode because you want to make more money, no matter how big or small a company you are. If your cars don't explode, people don't sue you. And that goes back to one of the very first points that was made about Rule 11. We have a legal system. People don't just sue for fun, typically. If they do, they get sanctioned. Our legal system is set up to ensure that frivolous lawsuits don't go anywhere. But I will say from firsthand experience, our system does not function at all when meritorious lawsuits are being blocked at the courthouse steps.
Wow, thank you. That's a powerful image, the idea of the exploding car parts. It doesn't matter the size of the company. We have to hold them accountable. And even the example you gave as well of these drugs being sold and that being a known person, a known account. If that was happening on the streets, that person would have been apprehended. And the fact that it's just allowed to freely flow on the internet is just such a travesty. Thank you so much for everything that your law center does on those matters. And just for time, I'll direct our last question for the panel over to Kristen Price. Kristen, what is the path forward? Is change to Section 230 of the Communications Decency Act possible?
Haley, I echo what the others have said. Section 230 needs to be repealed. I think repeal is appropriate because big tech doesn't deserve reform at this point. They've tried to avoid even the most basic accountability, despite being in an excellent position to make their products safer. And by excellent position, I mean extremely rich and therefore well able to absorb the cost of fixing this. So I think they absolutely need the message from us that we're done negotiating with them. Relatedly, big tech actively undermines attempted reform, as Professor Leary pointed out. They've had a seat at the table when it comes to policy making, and they can and they do neuter legislation with language that undercuts the proposed reforms. They also run search engines, and they allow misinformation about reform bills to dominate search results. And even getting a reform past big tech is only the first step. As we were just discussing with FOSTA, laws still have to be interpreted, and judges consistently interpret Section 230 so broadly. Just to give a quick example, in one of our cases against Xvideos, Pornhub's rival, the judge, because we made the argument that tags and categories and the thumbnails that Xvideos was creating and altering were part of them essentially developing the content and contributing to the illegality. The judge said all of these features, including their suggested searches, even when they suggest the term toddler, all of this is neutral and all of this is immune under Section 230. So this is why repeal is the best option. There's nothing to negotiate or interpret. Repealing Section 230 wouldn't make any website automatically liable for anything. It would just remove the immunity and end the special treatment so that they can be sued like any other company for the damage that their product or service is causing, returning the risk of doing business to the entities best suited to absorb it. I do think repealing Section 230 will certainly be difficult, but I do hope also that what everyone takes from this conversation today is that it's a fight well worth having.
Brava, Christine. Kristen, thank you so much. Very, very well put.
Yes, thank you so much to our wonderful panelists. We really appreciate you joining us today. We do now have to move over to our impact panel, as we have seen that Section 230 of the Communications Decency Act is stopping survivors from receiving justice and is halting online platforms from having the necessary incentives to prioritize safety. So let's now zoom out and look at what are the consequences of an internet without accountability. So we'll move now to our final panel, and I'd love to introduce them now. Lauren Coffrin, Executive Director of the Exploited Children Division from the National Center for Missing and Exploited Children. Melanie Thompson, Chief Advocacy and Outreach Officer at the Coalition Against Trafficking in Women. Ava Smithing, Director of Advocacy and Operations at Young People's Alliance, and Tim Estes, CEO and founder of Angel Q. Thank you all so much for joining us today. And Lauren, I would really love to start with you. As you work at NCMEC, your organization sees some of the worst of what the internet has to offer. I would think, hopefully, that with improving technology, that maybe the issue of abuse online is getting better, but that doesn't seem to be the case. Could you share about some of the trends that your organization is seeing?
Sure. Thank you so much for having us here. As a quick background, for those who may not be familiar, the National Center for Missing and Exploited Children, or we say NCMEC, we operate the cyber tip line, and it's the nation's reporting mechanism for the public, as well as for tech companies. They're required by law to report any instances of apparent child sexual abuse material to law enforcement via our cyber tip line. And so this year, with the passage of the Report Act, companies are now also required to report instances of online enticement of children and child sex trafficking to the cyber tip line. Our job is to be able to add as much value as we can to these reports, get them out to law enforcement around the globe. But as technology evolves, we're actually able to track new and growing trends that are involving exploitation, and we base these trends around our data and our facts. So unfortunately, what we're seeing, one of the most significant trends is the growth of online enticement, a major issue that really picked up steam during the pandemic, but has continued to escalate ever since. Reports last year skyrocketed. So in 2023, we saw about 186,000, but it jumped to over 500,000 in 2024. That's almost a 200% increase in just 1 year alone. We see a bunch of other concerning trends, like the usage of online platforms by violent online groups. These groups are, not very well structured and formed, but they target vulnerable children children who are in online boards or servers or threads, gathering, trying to find help regarding maybe eating disorders, self-harm, or other vulnerable issue areas. And the reports that we read, they have offenders that are coercing children into extreme escalating factors like self-harm, suicide attempts, bestiality, animal abuse, child on sibling sexual abuse. And in 2022, we saw like less than 100 of these type of reports. But last year, we saw over 1,000. 1,000, that's a 400% increase. And to be frank, most of the reports are coming in primarily from members of the public themselves, who are parents, concerned kids who are being flagged and looking for help out there. When we think about other trends, many of you may be aware of financial sextortion that continues, unfortunately, to be on the rise. Traditionally, child sexual exploitation is motivated by a sexual gain, yet financial sextortion focuses more on that monetization of youth. Children are deceived or blackmailed into creating child sexual abuse imagery, then threatened to be able to share or to expose those images unless they pay a huge and a large sum. Those threats are severe. They are swift. They have these extreme consequences, including, unfortunately, the death of over 30 teen males that we know of right now. And despite the efforts of government and NGOs and companies themselves, these reports continue to rise. 10,000 in 2022, 26,000 in 2023, over 30,000 in 2024. And we are not making the impact that we need to see and not seeing the reductions that we'd like to. And now, with the advent of and the ease of finding artificial intelligence, that's generative AI being used to create CSAM and the exploitation of children. We see it in text-to-text, people looking for grooming chat, words they can use to entice children, even manuals that can instruct bad actors how to abuse and to exploit children. We see text-to-image, individuals who are typing in words asking for this AI to create them synthetic images of children being abused. And even worse, images being used to create more images. That is taking child sexual abuse material images, uploading it, asking for customized new images. A neighbor's child's head on a known image of child sexual abuse material, editing sexual acts, uploading innocuous images of children and using them for CSAM blackmail, like in financial sextortion, or using these undressing or nudify apps. And worst, while it's not new, historical CSAM just continues to circulate on platforms online. I think of a case example of, two prepubescent males whose images were first known to circulate in 2017. And as of now, we are aware of over 8.2 million instances of these images being circulated, just that we're aware of from reports. So whether it's CSAM online, whether GAI, financial sextortion, all of these examples I'm giving, these are just a few of the growing trends that we see of how technology without proper guardrails are being used to exploit, to target, to abuse children with often irreparable impacts.
So disturbing. Thank you for that detailed report, though, Lauren. Melanie, this isn't only an issue of child sexual abuse. How does prostitution and sex trafficking play out online?
Yeah, thank you, Eleanor. And you're absolutely right. It's not, right? The internet and tech platforms have continuously exacerbated sex trafficking and online exploitation. And we've seen this heightened increase during COVID and even beyond. And one of the most dangerous facts about these platforms is that it can be used to target both the victims and the perpetrators. So I'll give an example of this. In our most recent federal human trafficking report of 2023, over 59% of sex traffickers use the internet to solicit sex buyers. So they were putting out these ads and trying to entice, if you will, sex buyers to come so that they can continue to sell, unfortunately, their victims to them there. But on the other side of this coin, in the same report, they also found that 60% of sex trafficking victims were also recruited online. And of course, when it comes to statistics. These are just the numbers of reported cases that they could find, right? And we know when it comes to sex trafficking and online exploitation, many survivors and victims go under the radar, unfortunately. We also know that the top 3 social media platforms that were used for these recruiting tactics were Snapchat, Facebook, and Instagram. And of course, there's many others that are a little bit smaller scale, but still very much contributing to this problem. In 2018, there was another study of 260 survivors who were domestically trafficked as minors. And out of that number, over 75% reported being advertised online and on these social media platforms. And as my colleague was just saying, these numbers continue to increase. And these are just the reported numbers that we can tangibly get facts and information on. I can speak, from my own personal experience. As a sex trafficking survivor, I was also sold online. And this was some years ago. And what I'm seeing is that although we're making small changes and strides, the trends remain the same. Lauren from NCMEC just talked a little bit about the online grooming, and we know that it starts as child sexual abuse, it starts as online enticement, but then it can very easily, the pathway from that all the way to sex trafficking, the trajectory is still there. And unfortunately, this is what a lot of traffickers are using, especially now that AI is on the rise. Things like deep fakes and all of the other, so on and so forth. What we see is that these traffickers are becoming more innovative as tech is becoming more innovative. And unfortunately, I think we all on this call can agree that 230 needs to be repealed and that tech companies are not doing enough to actually put some things in place to stop this problem.
Exactly right.
Thank you so much for sharing that. And just exactly like you said, tech companies are not doing enough. And just hearing both of what you have shared, some of those numbers are just personally to me so overwhelming. And it just makes me think about how often tech lobbyists are up on Capitol Hill saying that if CDA 230 is repealed, if Section 230 is repealed, that it will break the internet. The internet's already broken. This cannot continue. This is not acceptable in a modern society. We should be using technology to flourish and to move forward as a society. We should be using these improved innovations. These improved innovations shouldn't be being used by sex traffickers and child abusers. They should be being used by the tech companies to intervene, to stop, to do better. This cannot continue anymore. Ava, I would really love to hear from you as you're working with young people. What do you wish that legislators, many legislative offices are viewing this online and will view the recording later. What do you wish that legislators knew about youth's experience online?
Yeah, thank you for that question. I think it's a very, very important one. I think we can break it down into a couple different categories. The first one is the truly addictive nature of these platforms because of the way that algorithms function to deliver young people with content. So they're running at a variable reward schedule, which means that young people do not have the mental capacity, who already can't self-regulate, by the way, to stop looking at the content. So it's not only the content that itself that is made incredibly more extreme by these algorithms, but it's also the rate at which this content is getting delivered. Because of how random it is, you don't know when the next positive thing that you're going to see is going to come, and therefore you can't look away. So that in and of itself, it is addictive. But on the other side of it, young people are trying to figure out who they are. They're incredibly peer sensitive and they want to be accepted by their friends. So not only is it actually chemically addictive, but on the other side of things, the likes, the comments, the ephemeral stories, seeing things that are going to go after 24 hours, that is addictive as well, because you want to fit in and you need to be on these platforms in order to be socially accepted. And you're a young person who cannot, or who is incredibly peer sensitive. So that is even heightened for you. And given those two things together, what I would really want to tell legislators is the Stockholm syndrome of it all, really. Young people have never experienced anything other than these social media platforms. I was born in 2001. I can barely remember what life was like before Instagram came in and took over all of my social interactions. The children who are younger than me cannot remember that world at all. So for them, this connectivity that Instagram is promising, this community that these social media platforms like Snapchat are promising, that is real to them. That is tangible and it's all they know, so they can't expect more. On top of that, the information that they're getting from reading online, they feel as if they're learning so much because these videos are teaching them, but they do not know that they can learn in ways outside of that, that there's a whole world to explore outside of that. So the issue with a law like Section 230 is it's preventing a lot of lawsuits from going forward. And the discovery that we would get from those lawsuits would be an incredibly critical piece vault of information that would allow young people to understand the harms that they're going through are not self-inflicted and that they are the fault of big tech companies. If we could move these lawsuits forward and learn more about the harms that young people are suffering online, that information would be incredibly empowering for young people to then be able to advocate for themselves because it would help them understand that it's not their fault. If you shield tech companies from liability, they will look as if they're not liable even to their victims, right? If we keep saying and blowing smoke or throwing fuel on this fire that tech companies have no liability at all with Section 230, young people will believe that tech companies are not liable for the harms that they are facing.
Very interesting. Tim, you're a technologist. You've been an insider. And so I look to you to ask you, what could these companies be doing better and why aren't they doing these things already?
Well, I did want to pick up on something that Haley just said a little minute ago, which is, the claim that these changes, won't break the internet. Well, they won't break the internet, but they'll break their internet, the one they've made fortunes from, the ones that have cost millions of kids' health and lives. That's the internet they don't want to break because that is their net worth. And so to make this concrete, we had a lot of really good high-level discussion and also some great information imparted from the earlier panelists. I want to drill into one specific episode. So last year at the Senate Judiciary hearings, which had 5 of the top tech CEOs justify and rationalize their lack of efforts to protect children, besides the empty apologies and the fake affected empathy, there was a massive deception that was perpetrated. So during one section of that hearing, Senator Cruz confronted Mark Zuckerberg with evidence that Instagram would show warnings when users search for and try to retrieve potential child sexual abuse materials. When asked how they could design a warning that would allow users to bypass the warning and look at that material, Mark Zuckerberg rationalized that design choice by saying, "Oh, we could be wrong." Well, that was effectively a lie. The technologies existed and been proven since 2019 and beyond that can identify CSAM with 99% accuracy or greater. One study even pegged the technology at 99.9% accurate. Hashing-based approaches are nearly 100% like Thorn's Safer product, which Instagram doesn't use, by the way, though they know all about it. Even fuzzy probabilistic matching for harder cases like videos is often 95% accurate. So Mark wants us to believe that they are somehow defending freedom by facilitating felonies, facilitating child abuse 99% of the time, rather than put a basic review process into place when these techniques flag content. A simple presume to protect versus a presume to engage bias would have literally stopped the harm to millions of children in this country for the last decade. But because of how Section 230 has been implemented and how it's been interpreted in the courts and weaponized by the lawyers for these firms, they have essentially been allowed to be criminally complicit and negligent. And these feckless leaders have shamelessly misrepresented the truth to the American people over and over again to protect their digital narcotics business, which is what it is. I think Ava made a great point. What she described essentially is how a digital narcotic functions using a combination of technology design and social pressures that are understood by psychologists who work for these companies, who engineered these things to drive engagement so that instead of spending a healthy amount of time online, like an hour or two, getting all you need, normalizing the behavior of spending 8 hours online by teenagers, which is the weirdest contortion of childhood we could have imagined in the internet. So I think that the time has come for us to essentially, say, as has been said earlier, it's time for that protection to be ripped away because they've abused the protection to facilitate criminal action to the scale of millions of events. Okay? If a normal human being kept this stuff on their servers, on their personal computer, the FBI could come in and raid their house and take them to jail. But somehow a multi-hundred-billion-dollar corporation can keep this stuff on their servers and have the tech to know about 99.9% of it and not have any liability, and have their own team members flag that this is going on, and it get escalated to the leadership of these companies, and then shoot down and veto the very approaches that would have protected the harms. So that is this bizarre dystopian reality where they can spend $60 billion, as the plan is to spend on AI servers with Meta just this year. And for a tiny fraction of that, they can roll this kind of technology out across their platform in days or weeks. And so the idea that we essentially have unfortunately been trading these children's lives for the very substantial wealth of a few, and the wealth of a few attorneys that have been lying on their behalf for a long time about what's actually going on, at some point there needs to be a reckoning. And I think that we're coming up on that. I do think there is hope, but until there is a reckoning, this is not going away. And I think the longer it takes to get that reckoning, probably the less. I mean, I can imagine this goes on much further. We won't be talking about repealing Section 230. We're going to be talking about piercing the corporate veil for these corporations where they have been actively negligent, leading to the ruining of lives, and they knew about it. And in other industries, if you were that negligent, you go to jail. I don't care how many billions you have. So for some reason, we decided that they're different. Well, guess what? They're different because they're worse.
They're different because they're worse. Keep that in mind. Lauren, you, through NCMEC, you do go and tell companies what you're finding, do you not? What are the companies telling you about the steps they're going to take to ameliorate some of the harm that you documented through the cyber tip line?
Sure. Yeah. So we provide feedback on the cases that we receive from law enforcement. Sometimes that is that the companies are not providing enough information to make these reports actionable. That information is important to pass on, but it has to be quality. It has to be robust information. So we are always trying to be able to kind of improve so that it's more than just a check the box of a mandatory minimum of what needs to get reported, but truly what pieces of information can help lead to the effective prosecution of those bad actors that are seeing in that. We at times are also being notified by members of the public when their images and videos are being transmitted, posted, shared online. And so oftentimes they are documenting the difficult nature of it is of working with companies, reporting mechanisms that can sometimes feel like a black hole, or they might not be getting those responses. And we hear that time and time again. So really, the National Center has certain aspects and pipelines that we can kind of use to be able to help expedite those, to make notices to the companies, hopefully for that takedown. Yet it also should not require, a national organization like ours to be that conduit. We would hope that the average American experience, that just as easily as it is to be able to post, it would be as easy to be able to get that content and get those images taken down. And unfortunately, that's just not the case as it exists right now. So there's certainly still a lot of challenges to the reporting process, to how we see companies responding, making these kinds of reports, and ways to be able to kind of improve the active steps, some that are required by law and some that are also voluntary as well.
Well, as we're coming up to our close, it's been mentioned a couple of times this hearing that happened last year in January with the CEOs, and how really nothing has happened in a substantial way since then towards accountability, other than in 2024, at least $51 million were spent by big tech to lobby on Capitol Hill. So I would love to hear, just open question for anyone who wants to say, if big tech were to redirect some of that effort away from protectionism towards prevention, if big tech was to prioritize, all online platforms were to prioritize safety and care, what would that look like? Can anyone paint me just a picture of, if we can shift their incentives back to be in line with the American people, to be in line with preventing sexual abuse and intervening with sexual abuse when it happens, what would we see? How different would it be to experience that world online?
I think
Maybe
there's,
Ava.
Yeah, I was going to say, I think there's a really clear and crisp example of what that would look like in the state attorney general lawsuit filed against Meta. I'm sure many of us have heard about Project Daisy, this idea that Meta tested on their own. What would happen if we were to default like counts off for young people because we know these make them participate in what is called like negative appearance comparison, right? They're comparing themselves to other people and saying, if this person gets more likes than me, then it's because they're better, people like them more. And Meta found that if they turned like counts off by default, young people, their well-being skyrocketed. They felt so much better about themselves on these platforms. However, they decided not to implement this change because it would impact their bottom line by 1%. So this question that you ask is really interesting to me because I don't even think this future is far off. All we have to do is look through these court filings and see all of the things that Meta chose not to implement, that Snapchat chose not to implement because it would impact their bottom line. And that's the future we could live in. We could live in a world where, say, we don't have like counts. We could live in a world where young people's follower lists are private by default to protect them from exploitation. All of these things that they have been sitting on and waiting and wanting to do, but will not do because they know it will impact their bottom line. They exist out there. We don't even have to get that as much as I would love to get that creative about it, we don't even have to go that far.
Thank you so much, Ava. I think those are perfect words to end on, that this future where people can flourish online is actually not that far away and we can achieve it. Thank you so much to our amazing panel. To close out, I would love to hand it back to our colleagues Marcel Vanderwatt and Kristen Price to close.
Great. Thank you, Haley and Eleanor, and just everybody on the panel. There was just so many things that stuck out. Just briefly, I was just thinking about something that Tim said. It's been about 13 years ago when many of us was in the room when Mark Zuckerberg turned around and apologized to the parents. And to Tim's words, there needs to be a reckoning. And until then, things are just going to continue. And something that Professor Leary said is that a piecemeal approach is just simply not going to work. Radical change needs to happen right now. Yeah.
This impunity will not last forever. Together, I believe we can build a world, a new, a different, and better world where accountability is part of big tech's reality. With determination and with hope, we believe that such a world is possible, and we thank you for joining us today.